Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Today I have an awesome expert guest, Olga Isaeva, who is joining us. And Olga is an IP lawyer at IZON and head of the IP Club at the International Cooperation Department. And she's also a graduating PhD student at the Institute of Legislation and Comparative Law under the government of the Russian Federation. Olga, welcome to the show.
Thank you. Hello, everyone.
So we're going to be talking through the Russian approach to regulating image rights, because in this third season of Image Rights by N. Mashinini, we are looking at the BRICS nation. The first episode, we did a Brazilian perspective, and now we are on to the Russian perspective. So, Olga, just for starters, can you maybe take the audience through a brief overview of how image rights are recognized and regulated in Russia?
Yeah, indeed. In Russia, indeed, everyone have right to her image, but there is no clear position on what it is in this or that case. We have an article in our civil code recognizing a right of a person to their depiction, meaning that no one can publish an image, meaning a photo or video or any other depiction of a person without a clear consent or permission of that person that is depicted on this photo or video. But at the same time, we have an opinion that there is an opinion stating that an image of a person can be a personal data of a person. Moreover, it is more than that. It is a biometrical personal data that is a specific data. So, and the courts have to consider any dispute on a case-by-case basis, deciding whether it is a personal data or it is just a depiction. For the regimes of these two photos are different. I think it is so in any country. It is so, if we speak just in brief, if you want me to, I may go more in detail, stating when it is a biometrical personal data, when it may be a biometrical personal data, and when it is just an image, what are exceptions, what rules are for image to be deemed just a depiction. So if you need such details, I may explain them as well.
I think to give it a more practical touch, to explain the detail, let's talk about the litigation trends. So firstly, has there been litigation on a person's image as a depiction, and secondly, as biometric data? And what are the trends in the courts, and how do they interpret it in each instance?
Actually, it usually happens that a person comes to court claiming that his or her right was violated. And when a person comes to court, they claim a violation of a particular article. So they claim either violation of an article of a civil code, which is explains an image just like a depiction with no relation to personal data, or they claim violation of their personal data rights. So, and if the basis of a claim is not correct, for example, if a person claims violation of their personal data, but there is no personal data at all, then a court just rejects that claim, and the dispute has no, I know, logic end for that applicant. So it is always, I would say, important to find a correct basis for your claim. To be more specific, I would say that people usually claim a violation of their personal data rights when it is possible to identify a person through their depiction, no matter whether it is a photo or video, but it is more often happens with photos. But we have a state standard, a standard approved by a state, where it is explained that to be considered a biometrical personal data, there shall be some requirements met, and those requirements concern light, position of a person, clarity of the face, and so on, so on. So there are many conditions. And indeed, when we just take a photo through our smartphones, it's I think never so, and that is why such a photo cannot be considered a biometric personal data and just a biometric photo like we do for our, I know, foreign passports, for example. So it is always a different story. But if we speak about just a depiction, it may be actually any photo, any video of a person, probably even an art, for there is no limitation of kinds of depictions. So it is said just photo, video, or any other depiction. So I believe it may be a work of an artist, just a painting or something else. It is my belief, as I said. But there are also some exceptions. If a person, for example, was paid for such photos, it is just a usual story when we invite a photographer to make some pictures, make some beautiful photos, and then use those photos in our social media, in our social networks, sorry. And then we go to that photographer saying, you cannot use those photos, blah, blah, blah. But if a person as a model was paid for such a session, then that person cannot prevent further use of their photos if there is no a particular agreement between that model and the photographer. It is the first exception that is listed in our civil code. So if a person was paid for a photo session, then their right would not be deemed violated if those photos were used without clear consent. The second exception concerns photos made in public places or during public events such as concerts, conferences, any sport events. So when there are a lot of people at the same time, and there are indeed always some photographers, journalists, so someone like that, and when they, I think almost always do some reportage or need any materials to be published afterwards. So if a person was present during such an event and that person was caught by a photographer, by a videographer, or by any other photographer, then a right of a person would not be deemed violated if only a depiction of that person is not the core of the object used. So to be more clear, to explain it better, I would say if we have just, for example, a picture of many people, of a lot of people stating on a stadium or sitting in a concert, and one of those, I know, 10 or 100 decides that his or her rights were violated and comes to court stating that he or she has not given a expressed consent to use his picture, then the court will just dismiss that claim, because a depiction of that person is not a core element of that picture. But if we use a picture of a particular person, even if it is received during a public meeting, then it may be disputable. For it is a picture of a particular person. If there is no one else on that picture, then it is possible to claim that a right to my depiction was violated. But it happens rarely, I would say. I've not managed to find a case law with such a history, when a person was caught during a public meeting or just public event and then claimed a violation of their rights. For people usually happy to have their personal photos during caught during public meetings. So it is the second exception. And the third exception that we have concerns state, social, or public interests. It is the most strange exception, I would say, for it is always the case that journalists challenge any object any claiming on violation of someone's rights, stating that this photo is made in social interests or in public interests. And they always say that even any picture of a public person may be justified by public interests. For this person is public, the interests are public. Public wants to know everything about life of that person. There were some disputes on that basis. There were court decisions that proved such position, but there is no, I would not say that there are many cases with such justification, but there were some explanations of our Supreme Court, and this basis is the most strange, the strangest, as I've already said, and I don't know, I still don't know what exactly is included in it. So for me, public interests are, I don't know, something that is really important for a public. So our security, ecology, I don't know, some state interests, but not a private life of a particular person. And here we come to another article of, that is in our code, right to protection of private life. And sure, those who believe that their rights were violated can claim violation of their private life. And I'm saying about that second article because right to private life and right to depiction are both articles, are both rights that are included, that are considered intangible rights in the Russian Federation. That is why they are close, quite close, and a person may claim actually both. While if a photo or a video was made, if a person was caught just in their private life, for example, sitting, I know, in their home, and a photo is made through a window, then it may be considered an intervention into a private life of a person. And if such a photo was published, then there would be, I believe, two violations. First, violation of right to depiction for a person have not given an express consent to use their photo, their depiction. And second, intervention into private life. So it always depends on the situation, on a person, meaning whether it is public one or it's just an unknown someone. And probably it also depends on the awareness of the person of their rights. Not everyone knows that such a use of a photo is unlawful or maybe unlawful. So people just agree, accept, and live their lives. But it may be unlawful, and in some cases, person may claim compensation, may claim violation of their rights. So it always depends on the situation, as I said.
And in addition to compensation, can they also apply for injunctions?
Yeah, sure. They may ask the court to make those violator to delete this photo or to, I don't know, publish any information. But if we speak about the internet, we know that if someone once entered into the internet, then it may never leave the internet. So it is the most complicated case. But if we speak about, I don't know, what cases it may be.
In the advertising spaces.
Yeah, if we speak about in the advertising spaces, then they can just stop use that particular advertisement, for example. But probably it is the simplest one.
Judging from what you've described now, there are slight differences in our jurisdiction in the South African context, but the bottom line is really the same, that there is protection for violation of a person's image, but also protection for violation of a person's privacy. I usually call these two sister rights because they really stem from the same family of rights, the personality rights that are founded on dignity, and even we also allow claims for compensation and the injunction, which we call an interdict in the South African context. So it's quite similar. The main difference that I'm picking up is that in your context, these are codified rules.
Yeah.
Whereas in our context, we are very much a common law jurisdiction. And so historically, they have always been sitting in the common law rules. And we do see some form of statutory embodiment of this protection through our recently adopted and commencement of the Protection of Personal Information Act. So basically, this is our, what I would call almost our copy and paste of the GDPR. And also things like Cyber Crimes Act, which was recently signed into law. So we are moving into having those, laws put in statutory documents, but historically and very strongly so, they're very common law based rights in our jurisdiction.
Yeah, as you said, those rules are exactly codified in our country, but those violations are quite difficult to be proven, actually. And even if a person proves that their rights were violated, the compensation is very unlikely to be high, or just, and people are usually want to have some compensation. And it shall not be just, I don't know, $100. They believe that compensation shall be higher. But I should say that there may be another case when an intervention into private life is that, how to say, is very serious, and then it, in some cases, may be deemed a crime. But it is just another story. There will be indeed a higher compensation, a real court decision that would punish that violator. But we shall not, I believe, consider those cases now. For those cases are very different. But if we speak about just use of a person's image in any context, then it is just a civil case. It would be a civil case, and the compensation is very unlikely to be high.
Which brings me to the question of how your laws then deal with the social media unique elements of influencers coming into the picture, for instance, and sometimes also memes and deepfakes being used on social media. Because a lot of times what I find interesting is, if we start with the influencers, these people are relying on their image to advertise and market brands. But there's the way they market is slightly different from traditional marketing, in the sense that they have to sort of depict a whole narrative that these are products that I use in my daily life. So it's riding very strongly on the personality of the influencer. So in instances where brands try and appropriate an influencer's image, or they try to associate themselves with an influencer or something like that, I tend to ask myself, should these rules apply in the exact same way to the influencer context, the way in which they would apply in the ordinary context, for instance?
Thank you for the question. It is very interesting, actually. As for the influence, the use of the influencer's image, I unfortunately am not aware of any recent case law with such a history, such a basis. But I believe that they would claim not violation of their image rights, but a violation of the other intangible rights, which are right to honor, dignity, and so on. For if a public relates that person to a particular product, for example, if I don't know, an advertisement agency decides to use a deep fake of a public person in their advertisement, but that person has not given their consent to the use of their image, and then the society starts to associate that public person with a product advertised, then that may be not violation of the image, for it is a deep fake, it is not an image of a real person, but it is more likely to be deemed a violation of right to dignity, right to honor, especially if that particular person does not want to be associated with that product. That is why in our country, I think they make some arrangements not to make such situations happen. For we have an advertisement with of a megaphone. It is our mobile operator. When there was a deep fake of Bruce Willis and another famous person, which is famous in our country. So that advertisement was very popular in our society. For Bruce Willis is known for people that are, I think, 35 years old and older, and another man that was real in that advertisement is more popular for young people, which are, I don't know, probably teenagers and up to 35 years. So they tried to have very, very large community, very large audience to attract attention to their product. And in that situation, they have a contract with Bruce Willis, and he gave consent to use his image in that advertisement. It was not even a sole advertisement; it was a series of advertisement. They even call it advertisement series. I'm not sure how it is called in English, but so there are several advertisements with a common subject, with a common story, and they appeared on different platforms, so on TV, on the internet, on mobile applications, mobile apps. So and it was really an advertisement series with a common with a unique history, but the relations with Bruce Willis were arranged in a correct way. It is for sure. Then appeared some fakes in our news that Bruce Willis just sold his rights to image to a company deepfake.
I remember that.
Yeah, it was a fake. He could not just sell those rights, for they are intangible. They cannot be sold. So he may give consent to the use of his image, to the association of his personality with that product, but that is all. If we speak about using memes or something like that, it is also a very complicated story. For, as we know, if one makes a meme, creates that object, then it may be just impossible to delete that meme from the internet. There appear many variations, many other stories made based on this meme. And I'm not sure that in that case, I'm not aware of any case, actually, when a public person claimed anything, when his image was used for the creation of a meme, and they did not like that meme. So I cannot say anything on this, unfortunately, but I may I don't know, imagine that if such a situation happens, then they probably may claim violation of their rights to honor and dignity. But another question here is, who will be a defendant?
Yes, especially one that has gone viral and people have also altered the initial text on the meme and so forth. There are too many possible defendants to go after.
Exactly. So the specific the meme is a specific object. There is no particular author, or it is I think always unknown. And we never know who defendant shall be in a particular situation. That is why we may claim just deletion of this photo from the internet, but all we know case when some popular singer claimed the deletion of her picture from the internet, and that photo appears every year on the internet on that day, just stating that it is, I think, another meme already. But every year, the same day, this photo appears again and again in many publics, stating, hey, it is the day when this photo was deleted from the internet. Congratulations, everyone. So yeah, it is impossible. Just when we speak about the internet in our digital era, it is not, it's not just a journal which we can fire, I don't know, go to the trash and so on.
And I think this is why there's been so much push for what is now called the right to be forgotten.
Yeah.
Although I do think the internet never forgets. So
I don't know how it works, how it may work in our reality. I know how it should work, how we believe it would work, but I'm not sure it would actually work so. But we'll see. Probably it will.
So another thing I just wanted to just ask quickly, from what you've been describing is, are the rights in the code strictly exclusive for public figures, or can non-public figures also access these rights?
You mean right to depiction, or which one? Yeah, it is just a general right which any person is entitled to. For any person is entitled to protect their right to depiction. Any person may claim violation of their rights. And actually, I was in a situation, even myself was in a situation when my photo was published on social media of, I don't know, something, I don't remember what was that, but my photo was published. I have not given my consent, but I didn't like that photo. And I just wrote to the organizers saying that, sorry guys, I don't want this photo to be published. Can you delete that, please? And they did so. So I did not have to write them something like, pursuant to Article 151.1, 52.1 of the Civil Code of the Russian Federation, blah, blah, blah. No, I just wrote them and they agreed, saying, okay, if you don't want to, if you don't want your photo to appear in our social network, then we'll delete it, no problem. But there may be cases when, there were actual cases when just a person wrote to such organizers saying that they don't want their photo to be published. They rejected their soft claim. And then those people went to court and they won and the court made those organizers delete that photo, or probably even write something. For there may be situations when a photo of a person is published, but next to the photo there is a name of another person, and it is not a very often case, but that happens, and then it may be misassociation of a person with some name, and in those cases they usually change something, either name or photo, depending on what is to be changed. So there are many variations of the situations related to the violation of the right to depiction, but any person is entitled to that right. It's not just a prerogative of public persons.
So that means that for parents whose children are used in memes, if they can identify a particular defendant who created the first meme, there could be some right of compensation based on this right of depiction, or other rights. In fact, even the privacy approach can work here.
They may at least try to. They may try to, if they first prove that that defendant is a correct defendant. It would be the first win, I think. And then the court will decide whether there is a violation or not. Probably there may be one of exceptions, which I listed before.
Yes, I was actually thinking of the public interest exception, because I think with public figures, there may be a much more room to raise the public interest defense. But with the non-public figures, I'm not sure if the public interest defense is so strong.
Probably not public interest, but there may be a situation when a photo was taken through public event or in any place which is open for visit, and it is also an exception. So if we take a picture, I don't know, on in any sports space or any place where people usually go with their dogs, for example. So this place is open for visit, and anyone can reach this place. That is why any picture taken in that place may be deemed an exception. If we just make a reportage, we make general photos of people staying there. If we do not focus on faces of particular persons, then it may be considered just a general photo and not use of a person's image, as I said. So there may be exceptions, and they are unfortunately very wide formulated. The wording is not that strict. That is why there is no that many cases actually on that article, and not only because it is almost impossible to receive a good compensation, but also because the wording is quite wide, and it is quite difficult to prove that your right was violated.
Yeah, it is quite difficult. Because the reason why I'm raising this question was one of the biggest points that I took issue with in my doctoral thesis was the use of people's images in memes, particularly when we're not talking about images of public figures, but basically just ordinary private persons. And more specifically, images that people upload, like, a selfie on social media, and then someone else repurposes it for a meme without your permission. Because I look at that unique situation because all these other contexts fall away. So it's not in a public space. It's not even, someone's not paid to take pictures of you. This is just a picture you maybe took in your private home, and you decided to put it as a display picture on maybe your Facebook page. And if someone appropriates that using screenshot technology and then turns this into a meme, there surely should be some form of recourse for this person to get either compensation or at least claim for an injunction to be put against a person who uses your image in this way. Because I don't believe that we should embrace a legal position that says that when you upload your stuff on social media, expect that people are going to reuse it. It's quite unfortunate that this happens so often. So this is why I've also ventured into finding out what are other jurisdictions doing about people's unauthorized uses of images on social media in particular.
Yeah, in our country, I know the cases when there was something like that, when an image or a story of just a person, not a public one, was published somewhere. And then in such cases, when it is impossible to find the source of this, the author of that meme or story, I don't know, something, then a person may go to the organization that published that information, or it may be journal, either internet or a paper journal, magazine. It may be, I don't know, the owner of a page in social media. Then they may go to court against that organization or person that used that image. Then that person may explain where they received that image, and then a chain is made, and probably they may find the author, the original creator, but I believe that that organization that published such false information may also be considered a violator in that particular case. So it is possible, but very difficult and quite disputable. But again, this happens not in our country that often probably, or even if it happens often, the society is not aware of such cases, they are not making it out loud. So it happens more often with public persons, for their images may attract may draw attention of people to a particular product. But if we use just an image of me, for example, I'm not that public yet, or still, fortunately. So they will not reach their goal if they use just my image. If they use an image of someone that is popular in our country, some, I don't know, TV person or singer or, I know, actress, then the conversion will be higher. And it is actually the goal that they usually, or if not always, try to reach. That is why images of public persons are more usable in those situations. But indeed, I agree that there may be cases when rights of any person may be rights of any person may be violated. That person is not necessarily to be public, and then they have to prove that their rights were violated. Then that photo or video or something shall be deleted. That compensation shall be paid to that person. That compensation is better to be not $100, but a bit higher. For moral compensation, something like that, but it's quite difficult.
Yeah, it is quite difficult. Even in our own jurisdiction, compensation claims are sometimes close to nothing, really. If you look at the impact that has been felt by the person whose image has been used without permission, it's not enough to cover. And there has been some criticism for this particular remedy that we used to claim compensation in such instances. But I don't foresee it changing in the near future.
In our country, if a person manages to prove there was a loss caused by such unlawful use of their image, then they may claim loss, again, compensation of losses, damages, or so something. We have we have several articles on different for different situations. And if we speak about violation of moral right of intangible rights, then there may be in these situations when such an unlawful use causes losses or damages. It is more suitable for public persons, again. Yes. Then they probably may claim not only compensation, violation of their right to private life, dignity, honor, but also compensation of losses and damages caused. Yeah. But it is also the case for private persons. For example, if someone uses my photo in a way that I don't want it to be used, and that photo for I don't know, my employer or another organization or a person that is important for me sees that photo in that context that I don't want it to be in, then it may cause me losses, it may cause me damages, and then I may go to court with a clear claim that use is unlawful. First, I have not given my consent to such a use. Second, I was not paid for this photo, for example. This place was not public, open to visit, blah, blah, blah. So I may prove that this photo does not fall under any exception which is listed in our civil code. And second, I would prove that first, I am entitled to compensation for violation of my rights, and second, I'm entitled to compensation of losses which were caused by such a use. For example, I don't know, I was fired because of that, or I have not received money from the bank for bank following that photo, for example. So those grounds can be proven by documents, and if something is proven by documents, then you may claim compensation of not only just some compensation, but compensation of losses, damages, depending on the situation. But it is, again, not always the case. It's, I would say, almost never the case. If we speak just about a general person. A general person may go to that publisher saying, sorry, guys, delete that. And they, I think, usually delete that because the profit of such a use is not that high.
Interesting, very interesting. So there is quite sufficient protection for image violations, if I could call it that, because of the various options that are available to parties to choose particular remedies that specifically fit their context.
It is, and it is not at the same time. It is because, yeah, we have different options, but it is not because we do not have specific option for this specific case. So if person know their rights, if they know the civil court, or they go to a good lawyer, then the lawyer will just show him all the variants. Probably they try to use all of those variants available. But if person does not know that, they will never find a particular article stating a responsibility or it's not responsibility, it is oh, I forgot the name. What? Doesn't matter. So injunctions for violation of image rights of a person. There is no such an article. There is an article, rights of a person to the depiction first, then where there are exceptions, which we already discussed. The first paragraph states that every person, no one can publish a person's depiction without their expressed consent. So that is all. And we have the second article, rights of a person to private life, to dignity, and so on. And again, there is no particular paragraph in that article stating that in case the rights of a person listed in this particular article are violated, then a person is entitled to this or that. No, you have to read the whole, not the whole, but you have to read the Civil Code of the Russian Federation to find an article that suits to the situation, and try to make the court believe that this article, your rights were violated first, and then you are entitled to this injunction, this compensation, or damages, losses, whatever. So it is complicated and difficult. So you have to make a lot of things to prove that you are right, your rights were violated. But yeah, you have such ability, you have such option. If you want to, just go to the court and make whatever you want.
It seems it's also costly to pursue, given that you need to probably get a lawyer whose expertise are really good in the field.
Usually, yes. For those cases, as we already said, a lot of times are complicated. Yeah. And to prove that your rights were violated, if it is not indeed just a photo which you received through your messages, for example, if you send someone your photo in a private message, and then that person that received your photo publishes that photo, it is a clear violation of your rights to a depiction, and it is easy to prove. So you have not published that photo, it was taken by yourself, it was sent to only that person, and that it is easy to prove. Probably it would not be that costly. But if we speak about more general situations, when a person don't want their photo to be published, when that photo was taken and published without their consent, but such a consent was necessary for such a publication, then it may be unfortunately costly. Yeah. If a person have a legal education or know some lawyers which are their friends and her family, it is another story. It may be not that costly, but in general, it may be for they have to go to court, they have to prove, they have to show particular articles, explain how those articles are applicable and why they are applicable, so on, so on. It is not that easy for just a general person.
Okay. And one last question about express consent. I take it that the code is probably very specific about saying express consent, so that consent is never implied or never really tacit. So is express consent meaning also informed consent here? Because I have an episode in the first season of this podcast where I talk about when people use images of homeless people. There may be a form of express consent where you've asked the person, can I take a video of you or something like that, and I'm going to use it on my social media page. But I wonder if that kind of consent is informed. In other words, does the person who's being depicted know the full extent of what their consent actually gives the other person permission to do? And I wonder how the courts interpret express consent in the code.
Yeah, I just opened the article. It is said that a publication of a person's depiction is permissible only if a person consented to such an action. So actually, there is no word express consent or expressly consented, but I think such a sense is included in that wording for if a situation appears, if a person claims that their rights were violated, then another party shall prove that rights were not violated because there was a consent. No one can prove that they have something, in our case, a consent of a person, unless they have a document or any other proof of this something. So usually they draw a specific document, consent of a person to the use of their image, or just it may be an agreement between the parties where there is a clause stating that private person gives or does not give their consent to the use of their image in particular situation. This may be a video recording if we speak about, for example, publication of video, a video session. At the beginning, they ask whether you are agreed to the publication of this video with your depiction or not. If they're not agreed, they may blur, for example, the image of the person. So there are decisions, and if another party just says that, yes, that person agreed to the publication, they gave their consent, but we do not have anything, then the court says, okay, you do not have anything, goodbye. So you shall always have something to prove that that person consented. If we speak about the publication of the information on the internet again, where the person, for example, fill the boxes, entering their private information and download their photo, there is a consent of that person, which is expressed by the actions of that person. So this consent may be proven by the actions. Consent may be proven by checking the box with the text, I give consent to this company or this person to use my image, to use my information. We often use such check boxes and during the registration on different websites, but they usually refer to the use of personal data, but there may be the case again with a depiction of a person, or in privacy policy may contain some provisions related to the use of depiction. So you have to read privacy policy as well before checking the box. But if we speak about just general situations when a person enters into contract with someone and that someone wants to use the image of that person, it is better to draw a specific document, which is called agreement of a person to consent of a person to the use of their depiction, where you stipulate the data of that person, you stipulate the conditions of the use of that person. So it is quite close to the consent to the use of personal data, which we give here in Russia. So you have to explain which data is to be used, how it is to be used, how long it is to be used. So if you give a consent to the use of your image for example, I don't know, 1 year, and you find your image to be used again in 2 years or 3 years, your consent already expired, and then you claim violation for you gave consent, but your consent was valid for 1 year only, starting from the date of its of the signing of the document. And you always have the second copy of the document, and you go to the court stating, hello, I have I gave the consent, but it was valid for until that period. Today we have another date, so it expired. Sorry, my rights were violated. And then it would be easier to prove that your rights are actually violated. So yeah, there may be again situations, and in this case, I think you will not have to prove a lot of things, for everything is documented. But if we do not have any document, we do not have anything to prove our position, then it would be complicated, if not say impossible. So yeah, that is why I'm saying expressed consent. For it is my recommendation to the clients, to anyone who wants to use the depiction of others, to receive an expressed consent. And it is better to be a specific document, which is not, it is better not to be just a clause in the agreement, for such a clause can be considered invalid in particular situation. So it may be accepted, but it may be also rejected. The courts do so depending on the situation again. If they believe that such a clause infringed the rights of a person, if a person could not change that clause, or if the person was made to even sign that agreement with no option to change that clause, then that clause can be just considered invalid. And so no clause, no consent of a person, no permission of that person to use their image. That is why it is also, again, I would say it is better to have a particular document related only to, focused only to the use of the image of the person, stating which image, or not which image, but where that image is to be made. If it is, for example, a specific session or a particular event, how this image is to be made, for example, in advertisement company, or on, I don't know, it is to be posted on the internet, or something else. And for how long it is to be used, if it is applicable. For example, if we speak about advertisement company again, we may receive a consent, or we may ask a person to give their consent to the use of their image, for example, for the duration of that advertisement company, saying we make photos now, and those photos will appear in our advertisement company. That advertisement company will last for, I don't know, 1 month, 3 months, 1 year, doesn't matter. And afterwards, those photos will be deleted, for we'll make new ones, we'll make new advertisement company, and something like that. Then it is it is a good scenario. And then they give just their those papers and go to the better future. So yeah.
With this duration issue, I know I said that was my last question, but now this duration issue, time period, is making me think about what is commonly referred to in the US states as the post-mortem rights. Can an agreement like this make room for the use of someone's image even after their death, so indefinitely? Or is that too excessive?
I'm not sure I may answer that question.
Because I'm just wondering, has the Russian lawmakers, have they thought about protecting the depiction of people even beyond their lifetime?
Yeah, sure. The right to depiction may be violation of the right to depiction may be claimed not by the person themselves, but also by their relatives after the death of that person. It is all, yeah, we have such a provision. It is also codified, and indeed, the relatives may claim that. And yeah, that consent shall be given by the relatives when the person depicted is not alive anymore. Yeah, we have such a provision, but if we speak about the duration of the consent, it is again just my recommendation when when people ask me how to draw the document, and if I understand that this use can be identified, I mean the period of time can be defined. So if they will really use it only for that particular period, and the use afterwards is not just possible. For example, it may be, I know, showing something on the billboard. Yeah. So it is not the internet, it is a material object. And after the particular period, it will disappear. Then it is applicable, but in most cases it is not applicable. That is why when we speak about using of person's image in a film, for example, in mass scenes, when where they just invite ordinary people, not actors, not actresses, just ordinary people, they pay them for such session. Those people act in mass scenes where they need to be not professional actors, and they write a consent to the use of their image, and it is stated that their image will be used in the demonstration of that particular film. They give the consent, they either paid for that or not paid for that, so it depends on the producer. But all actors of the mass scenes usually in good situations sign such a document, and so when they appear in a film on TV, they may not claim violation of their rights, for they first signed the document, and second, they are usually paid for that.
Okay. All right. Thank you so much. So the two biggest tips that our audience should take away in closing, what would that be?
First, answer the permission. Always answer the permission. Either you just take a photo, not only when you are publishing something, but first when you are taking a photo. When you're taking a photo, ask the person whether that person is okay with further publication. For usually, if you do not want to publish something, you're very unlikely just want to take a photo and to keep it with yourself under your pillow. I don't know. You want usually to publish it. So first, answer for the ask for the permission for further publication. If the person is okay, then okay, and that permission. And second, that permission is better to be documented somewhere, either in messages. It may be just a message in private message, are you okay with further publication? It may be, I know, audio recording. It's not preferable, but it may be. It may be signed document, but you shall somehow document the consent of that person. Yeah, if that person is okay with that, it is perfect. It is also better to identify the name of that person, but it depends on their desire. That is why it is not a tip. So ask for their permission and ask for the conditions of that permission, with name or not with name, particular period, particular context, so on and so forth. So, and document.
Okay. So where can our listeners reach you if they need to know more about this particular topic? Are you on social media? I don't know, LinkedIn, Twitter?
I'm not in Twitter. I'm not in LinkedIn. I'm in Facebook only if we speak about global social networks. My name is Olga Isaeva. My address there is written through OLYA, like Ola. It is a short name. And there is my picture, my depiction.
Thank you for allowing me to use your depiction. Thank you so much for what you've taken us through. It's very detailed overview of the Russian perspective of image rights protection. I'm sure the audience are going to appreciate this episode. Thank you so much and keep well.
Thank you for the discussion. It was very interesting. Would be glad to see you again.
Indeed, indeed.
Remember to control your image rights.